Hello, Agis.
Hello.
It's lovely to be here at Cyprus Arbitration Day. The excitement and the whole thing is so wonderful. Just wanted to ask you a few more questions.
Welcome to Cyprus. It's great to have you here and have you enjoy it.
So, the first question is, from the perspective of international users, what are the key advantages of choosing Cyprus as a seat for arbitration?
Well, there are many. I guess selecting a seat will depend on many variables, but it is often the case that Cyprus will meet a lot of them. First of all, because of its location, it's quite convenient to meet in Cyprus for arbitration hearings. For parties who are in Central Europe, Middle East, Asia, so it's also a very convenient geographical location. Secondly, it is a common jurisdiction, and many of these disputes that go to international arbitration are governed by common law. The facilities are here. There are some very competent professionals at all levels and for all the different professions that are involved in the process. So I think everything is here, we do hope to have more work in the future in this field.
In fact, if I may share with you, I was speaking to one of your colleagues, and there was a striking example of how all these things are met by Cyprus. So there was an ad hoc arbitration in Sweden between a Dubai party, a UAE party, and an Indian party. And then because of all these advantages, common law, competence, and the language advantage, so the Dubai firm actually has engaged a separate firm to assist them with arbitration in India, where they expect that the Indian party may seek annulment of the award. So they want to speak preemptive action. So what you were saying, I was really astonished that, it's this UAE party, Indian party, but the Dubai party chose to come to Cyprus to help them with their case in India.
Well, I'm not surprised because this is something that happens. We do get sometimes instructions to ask in cases like that. I asked for a case now which involves an English and a Bangladeshi party, and for similar reasons, they chose to appoint counsel from Cyprus, which is at least one of the parties. So it is something that happens.
Right, so that's very interesting. And, so the next one is the arbitration landscape is evolving rapidly with developments in AI, sanctions-related disputes, ESG obligations, and investment treaty reform. Which of these trends do you believe will have the most transformative impact on the practice of arbitration?
International arbitration is by its nature interdisciplinary. It's not an area of law where we can just follow particular aspects of it and be able to cope with what is happening. You need to be alert to changes in institutions, their bylaws, private international law, public international law. It is a very dynamic area, so it changes constantly. So, and lawyers involved in this area are accustomed to this sort of challenge. I think that probably the biggest challenge we face today is the sanctions implications and the response by certain states who are affected by sanctions by passing laws which negate arbitration agreements and vice versa. But in the immediate future, I think the biggest challenge would be AI, not in a negative sense, in a positive sense, in that we will have no option but to embrace it and harness it so that we can use it properly within this framework.
On AI, usually the argument that is made or the fear that people express is that AI will replace lawyers or will replace people. But do you feel that there is another perspective that AI could actually empower and give lawyers the freedom to actually focus on strategy and analysis and judgment, and sort of the judge work is done by AI?
Well, AI, not just in law, but everywhere, AI may replace people who are not willing to adapt.
Right.
So if we insist on working the same way that we did in the past, then obviously technology will suffer. I don't see AI as a competitor. I see AI as a tool, and a very useful tool actually, which we can use, and provided we can understand it and find ways of using it which do not have a negative impact on the quality of the services that we offer and the end result which we aim for, which is the resolution, fair resolution of disputes. And so if we find ways to do this properly, I think it would be a very useful tool of efficiency.
I think that brings out the right balance. You on how those who are willing to adapt, those who are willing to work with it, for them it will be a tool and an advantage. It's those who insist on not changing who might get replaced. So it's actually up to people on how much they adapt and how willing they will work hard with the new technology.
Yes, exactly. It's like the introduction of cars. I mean, if you insist on moving around with carriage, fine, but you would probably not be able to use the highway.
So, just one or two questions more. So, investor-state dispute settlement continues to undergo intense global scrutiny and reform discussions, and we had an amazing presentation on this just a few minutes ago. Do you see the future of ISDS moving towards structural reform or an entirely new model, especially in light of that presentation where we noted how much there is a pushback by sovereign nations toward enforcement?
I think it is difficult to disagree with the premise that ISDS must change. It is equally difficult to tell, though, which direction it is going. Because there are various proposals on the table right now. Introduction of the new generation of VIPs, possibility of a multilateral agreement, a discussion about the multilateral court, which are rather premature in the sense that we have not really crystallized on what is the line we follow. Some of the criticism against ISDS is very serious, and it has to be taken into account. I believe that somehow the system will, because it is rather versatile, I think that it will find its way to survive its problems, but I'm not sure about what the future will be. My prediction is that it will be a mixture. There will be, possibly at more peaceful times, there will be probably some movement towards new generation VIPs, but at the same time, I think that eventually there will be a multilateral investment court set up, but this may take several years.
Could you share if there are any moves that you're aware of towards this multilateral court?
Yes,
which countries are leading?
There is discussion at EU level, but I think the most serious discussion about it is antitrust, because it is discussing one of the working groups of antitrust, and it seems to be gaining momentum. I'm not sure if it will eventually proceed, but it looks like.
And I think especially if it's being spearheaded by UNICETRAL, that is already the standard. So there is a good likelihood that it may become acceptable because there are so many signatories to the New York Convention. That gives great hope, I think.
Well, I think so. I think that yes, it is a very let's say that it is being discussed at such a level at UNICETRAL makes it very likely that it will proceed.
Just quickly to our last question, and which I'm sure will be very interesting to know, is conferences such as Cyprus Arbitration Day play an important role beyond networking. They also shape dialogue and policy. What broader impact do you hope CAD will have on the international arbitration ecosystem?
We do have many different targets. I will just mention a few of the most important probably. First of all, I should mention that the Arbitration Day in Cyprus is a success, largely because we've managed to get the local community to Cyprus. So we have all these different law firms which are competing each other, working together for this event. So that's a very welcome development. Secondly, we are trying to get the attention of our government. We're trying to include in their strategy the development of Cyprus as a place for arbitration. We have not been very successful so far, but there seems to be an interest, and we hope that they will allocate some of their resources towards that direction fairly soon. Thirdly, this is a place which is very internationally attended. We have about 45% participants that are not Cypriot-based.
I believe 25 nations?
It's more than 20. I'm not sure if it's 25, but it's more than 20. So it is not just a place for business development. People come here because of the content. They feel that they can get information, they can, of course, develop their business at the same time, and also get experience Cyprus as a place where, of course, they have a good time and enjoy themselves while they're here, but at the same time, a place where they can come for business, including arbitration. So these are, let's say, our primary aims, and I hope that we will succeed.
If I may conclude on the note what Dr. Mahmood said, that unlike Mauritius, here you can do an arbitration the whole day and get to the beach by the evening.
True, or even between sessions.
Or in between sessions. Yes. Thank you so much.
Thank you very much.
And I'm sure
I appreciate your support.
Very happy with your views.